I'm going to go right into, all right, I'm just looking across platforms. Thank you so much for joining. I hope you will click share and tag someone to join in the presentation. We will continue our look at public figures today, and we will continue that through the end of the week. And next week, we will go into the arts, largely into the music of many of the great people in the African American experience. I believe the music is next week. Okay. All right. So I'm going to go right into tonight's presentation. So thank you for your patience. Constance Baker Motley was an unlikely civil rights hero. An African American who grew up near Yale University, she did not personally experience overt racism until late in high school. And as a young person, she was almost totally unaware of Black history. After a childhood largely free of overt racism, Motley experienced Jim Crow laws firsthand while traveling by train to a college in Tennessee. In Cincinnati, Motley was ordered into an aging, rusty car marked colored. She wrote of the experience, quote, "Although I had known this would happen, I was both frightened and humiliated. All I knew for sure was that I could do nothing about this new reality," unquote. Constance Baker Motley, September 14, 1921, born September 14, 1921, was a key strategist of the African American civil rights movement. She was a lawyer, a judge, a state senator, and a borough president of Manhattan, New York City. She argued 12 landmark civil rights cases in front of the Supreme Court, winning 9. She was a law clerk to Thurgood Marshall, aiding him in the case of Brown versus the Board of Education. Constance was born in 1921 in New Haven, Connecticut, the 9th of 12 children. Her parents, Rachel Huggins and McCullough Alva Baker, were immigrants from the Caribbean islands. Before coming to the United States, Rachel worked as a seamstress and a teacher while McCullough worked as a cobbler. Baker Motley describes her parents' education of being equivalent to the 10th grade in the United States. Her mother was a domestic worker, and her father worked as a chef for different Yale University student societies, including the Secret Society of Skulls and Bones. Rachel Baker was a founder of the New Haven NAACP, National Association for the Advancement of Colored People, exposing Motley to African American history, especially the writings of W.E.B. Du Bois, in her Sunday school. While in high school, Motley became president of the New Haven Negro Youth Council and was secretary of the New Haven Adult Community Council. In 1939, she graduated with honors from Hills House High School. Though she had already formed a desire to practice law, Motley lacked the means to attend college and instead went to work for the National Youth Administration. She also continued her involvement in community activities. It was through this work that she encountered local businessman and philanthropist Clarence W. Blakesley, who, after hearing Motley speak at a New Haven community center, offered to pay for her education. With Blakesley's financial help, she started college at Fisk University, a historically Black college in Nashville, Tennessee, but later returned north to attend New York University. At NYU, she obtained her Bachelor's of Arts degree in 1943, and Motley received her Bachelor's of Laws in 1946 from Columbia Law School. In October of 1945, during her second year at law school, future U.S. Supreme Court Associate Justice Thurgood Marshall hired her as a law clerk. She was assigned to work on court-martial cases that were filed after World War II. Richard Blum says, a former clerk who helped Motley research her autobiography, She was very admiring of Thurgood Marshall, extremely appreciative of him hiring her. He had no issue with her being a woman, unquote. Along the way, she experienced countless courtroom delays and indignities. Motley kept her cool, even as some judges turned their backs when she spoke. In her autobiography, Motley says she was never discouraged by doubts concerning her background. She writes, quote, "I was the kind of person who would not be put down. I rejected any notion that my race or sex would bar my success in life," unquote. Constance Baker married Joel Motley Jr., a real estate and insurance broker, in 1946 at St. Luke's Episcopal Church in New Haven, Connecticut. They were married for 49 years. From the late 40s through the early 60s, Motley played a pivotal role in the fight to end racial discrimination, putting her own safety at risk in one racial power keg after another. After graduating from Columbia University, a law school rather, Baker was hired by the NAACP Legal Defense and Educational Fund as a civil rights attorney. As the fund's first female attorney, she became associate counsel to the fund, making her a lead trial attorney in a number of early and significant civil rights cases, which included representing the late Dr. Martin Luther King Jr., the Freedom Riders, and the Birmingham Children Marchers. Baker visited churches that were firebombed, sang freedom songs, and visited Dr. Martin Luther King while he sat in jail, as well as spending a night with civil rights activist Medgar Evers under armed guard. As a frontline lawyer for the NAACP Legal Defense and Education Fund, Motley personally led the litigation that integrated the universities of Georgia, Alabama, and Mississippi, among others, overcoming Southern governors who literally barred the door to African American students. She opened up schools and parks to African Americans and successfully championed the rights of minorities to protest peacefully. In 1950, she wrote the original complaint in the case of Brown versus Board of Education, the first African American woman ever to argue a case before the United States Supreme Court. In Meredith versus Fair, she won James Meredith's effort to be the first Black student to attend the University of Mississippi in 1962. Motley was successful in 9 of the 10 cases she argued before the Supreme Court. The 10th decision regarding jury composition was eventually overturned in her favor. She was otherwise a key legal strategist in the civil rights movement, helping to desegregate Southern schools, Southern buses, and Southern lunch counters. Beyond her work with the Legal Defense Fund, Motley continued her civil rights work as an elected official. In 1964, she was elected to the New York State Senate and devoted much of her time to advocating for housing equality for majority Black and Latino low-income tenants. Motley also endorsed urban renewal projects and looked to improve the neighborhoods in New York City that needed aid. Motley was elected on February 4th, 1964, to the state Senate to fill the vacancy caused by the election of James Lopez Watson to the New York City Civil Court. She was the first African American woman to sit in the state Senate. She took her seat in the 174th New York State Legislature, was reelected in November 1964 to the 175th Legislature, and resigned her seat when she was chosen on February 23rd, 1965, as the Manhattan Borough President, the first woman in such a position. In November of 1965, she was elected to succeed herself for a full 4-year term. J. Raymond Jones was influential in helping her to reach these positions.
Welcome to Powerful Money Tools, LLC. At Powerful Money Tools, we are here to prepare for your future. we want to talk about financial freedom. Financial freedom is budgeting, credit building, and also financial education. So, once again, welcome to Powerful Money Tools LLC. We can't wait to help you in your financial future.
Motley was nominated by President Lyndon B. Johnson on January 26, 1966, to a seat on the U.S. District Court for the Southern District of New York, vacated by Judge Archie Owen Dawson. Senator James Eastland of Mississippi delayed Constance Baker Motley's confirmation process for 7 months. He was in opposition to Baker's past desegregation work, including Brown versus Board of Education and Meredith versus Fair. Senator Eastland used his influence as chair of the Senate Judiciary Committee to disrupt Baker's nomination and went as far as accusing her of being a member of the Communist Party. Despite opposition, she was confirmed by the United States Senate on August 30 of 1966 and received her commission, becoming the first African American female federal judge. She served as chief judge from 1982 to 1986. She assumed senior status on September 30th, 1986. Motley was the presiding judge on the case of Blank versus Sullivan and Cromwell, a landmark case for women lawyers. In Blank, the plaintiffs accused a law firm of sexual discrimination. Due to the nature of this case and Motley's gender and race, there were calls for Motley to withdraw from the case, assuming she would be biased. In response, Motley pointed to her history of impartial decisions, sometimes ruling against the plaintiff in discrimination cases. In Belknap versus Leary, another highly publicized case, Judge Motley admonished the New York City police for not providing veteran war protesters with adequate protection against violence in the streets. Constance Baker Motley ruled against the plaintiff in the case of Malarkey versus Borglum in 1970. This case involved female tenants in New York City arguing that their male landlord was violating their First and 14th Amendment rights. The defendant cited the landlord's overreach of power, but failed to detail the landlord's legal failings. Motley ruled in favor of the defendant, rejecting the plaintiff's claim of sexual discrimination and going against her former advocacy for tenants during her time in the New York State Senate. Motley handed down a breakthrough decision for women in sports broadcasting in 1978, when she ruled that a female reporter must be allowed into a Major League Baseball locker room. In Lutke versus Kahn, Melissa Lutke filed a lawsuit against Bowie Kahn, the Major League Baseball commissioner. The American League president, Leland McPhail, and 3 New York City officers, all involved in the suit over the New York Yankees' gendered policy forbidding female sports reports from entering the Yankees locker room. She received numerous awards. She received a Candace Award for Distinguished Service from the National Coalition of 100 Black Women in 1984. In 1993, she was inducted into the National Women's Hall of Fame. And in 2001, President Bill Clinton awarded her the President's Citizen Medal. The NAACP, awarded her the Springer Medal, the organization's highest honor, in 2003. Motley was a prominent honorary member of Alpha Kappa Alpha sorority. In early 2006, she was honored by Senators Charles Schumer and Hillary Clinton with a Congressional Gold Medal posthumously. As Motley had a distinguishing career in civil rights, the senator only thought it fitting to award her. During the early 21st century, Motley became a part of the Just the Beginning Foundation, a foundation dedicated to preserving African American judges who improve the African American community through their work. During her time as a federal judge for the Southern District of New York, she made efforts to reach out to other African American women in her position. One of the women she reached out to was Judge Ann Thompson, who received a personal note from Motley on the day she was appointed to be a judge for the District of New Jersey. Vice President Kamala Harris explicitly cited Constance Baker Motley's influence on her own political and law career on her campaign page. An award-winning biographical documentary, Justice is a Black Woman, The Life and Work of Constance Baker Motley, was first broadcast on Connecticut Public Television in 2012. A documentary short, The Trials of Constance Baker Motley, premiered at the Tribeca Film Festival on April 2015. She was revered by the many judges and clerks she mentored.
Hi, my name is June Rochelle, and I own Detroit Couture. We are a fashion-forward women's boutique, and we offer friendly sizes from small all the way up to 3X women's sizes, very generously fit, very great quality. I actually have on one of our pieces today. It's called the Cuffed Up. It's in gray, burgundy, and black, and olive, and it actually has a lot of stretch and give. So listen, in this time, we try to make sure that, first of all, it's quality and customer service that we offer our clients. And I'm so glad to have this opportunity to share with you. So go and visit us at DetroitCouture.com.
In 1998, Motley published an autobiography, Equal Justice Under the Law. On one subject, she revealed her inner fire, the sting of racial discrimination. While juggling discrimination cases and desegregation cases, Motley occasionally represented Dr. Martin Luther King Jr. In her autobiography, she recalled visiting King in a stench-ridden jail outside Americus, Georgia. She writes, quote, "The temperature must have been 100 degrees. We could hear other prisoners in a back room yelling and moaning. It was then I realized that we did indeed have a new civil rights leader, a man willing to die for our freedom," unquote. And perhaps her most famous case, Motley, with the backing of the Fifth Circuit Court of Appeals, helped James Meredith gain enrollment at the University of Mississippi. Campus riots broke out when Meredith registered, killing 2 people. Federal troops were called in to restore order. The threat of violence was constant during Motley's trips to the South. Barred from hotels, Motley stayed with local rights activists. Even when armed men stood watch, she found it difficult to sleep. One frequent host, Mississippi civil rights leader Medgar Evers, was fatally shot in his driveway. The assassin hid behind a large hedge that Motley had urged Evers to cut down. Away from the courthouse, Motley found solace in an 18th century Connecticut farmhouse where she and her husband Joel relaxed and invited friends for weekend visits. It was an old rustic house. You could walk into the fireplace, Judge Ann Thompson writes. It was in the woods and she loved it. Even as Motley prepared her autobiography, she stayed characteristically humble about her legacy. Bloom writes, who assisted her with the biography, she felt very lucky, like she was in the right place at the right time. The civil rights movement was the movement of an era. It changed our nation's history. She died on September 28th, 2005, of congestive heart failure. Her funeral was held at the Connecticut church where she had been married. A public memorial was held at Riverside Church in Manhattan. So there are heroes who are sometimes greatly sung, like Thurgood Marshall. You hear that name and you know exactly who he was and maybe some history about him. and maybe not as much about Constance Baker Motley outside of legal circles, but she was a first in many regards. And so I am so honored to be able to pay tribute to her as our Black History moment today.
Marcus, I want to congratulate you on Love and Stuff. I really want you to know that staying grateful and understanding the power of what it is to be operating out of a space of abundance and gratitude is the most important part of every journey of every day. So Marcus June, congratulations on this book. It's on Amazon now. That makes me so proud of you and your family and me and my family, and every single person around us gets it. So good on you for bringing it into the hands and the laps and the Kindles of all the people. Okay, so we're gonna check it out. Can't wait to learn more.
Neither slavery nor involuntary servitude, except as a punishment for crimes whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Hi, I'm Marcus Holmes, and we continue throughout this month to bring you Black History Month reflections, which will include some of the maybe not so positive moments in our Black history experience and if we don't learn from them, we may be bound to repeat them. Those were the words of the transcript of the 13th Amendment to the U.S. Constitution that abolished slavery, or did it. Section 2 of that amendment says Congress shall have power to enforce this article by appropriate legislation. So I wanted to open this session with no music and just the mug shots of some of the early 19th century persons that were convicted and that were imprisoned in this system. Our Constitution's fourth article is devoted to the relations between the states and the Union. And Section 2 of that article sets forth 3 clauses, each of which concerns the movement of persons throughout the Union. The first of these, the Privileges and Immunities Clause, stipulates that the citizens of each state shall enjoy the privileges and immunities of citizens in the other states. Conversely, where the interstate traveler is a fugitive from criminal justice, the second provision, the Extradition Clause, requires the person's forcible rendition to the state where the alleged crime occurred. Finally, the Fugitive Slave Clause, which was effectively abolished by the 13th Amendment, extended this rule of coercive rendition to interstate fugitives from slavery, that is, fugitives from injustice. It says no person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such labor or service may be due. Before the Civil War, the Fugitive Slave Clause and the Privilege Immunities Clause occasioned intense national controversy. Americans disagreed about both the scope of these provisions and the degree to which the federal government had some implied power or duty to enforce them. These legal disputes in turn reflected deep political divisions on questions relative to slave ownership, race, and citizenship. So from the National Constitution Center, the third clause of Article 4, Section 2 is known, of course, as the Fugitive Clause. It's one of 5 clauses in the Constitution that dealt directly with slavery, although it doesn't use the word slave. It instead refers to persons held to service or labor. Compared to the Slave Trade Clause and the 3/5 Clause, the Fugitive Slave Clause occasioned very little debate at the time it was adopted, but fierce conflicts arose about its scope and enforcement in the decades that followed. The clause was adopted at the Constitutional Convention of 1787 on the motion of Pierce Butler and Charles Pinckney of South Carolina. In opposition, James Wilson of Pennsylvania disagreed because this would oblige the executive of the state to return fugitive slaves at the public's expense. The proposal was withdrawn, but then adopted a day later with no dispute. The only response recorded was Connecticut delegate Roger Sherman's sarcastic comment that he saw no more propriety in the public seizing and surrendering a slave or servant than a horse, unquote. At the end of the day, since the word slavery was never mentioned in the document, Northerners could argue that the Constitution did not recognize the legality of slavery. However, Southerners such as General Coltsworth Pinckney argued, we have obtained a right to recover our slaves in whatever part of America they may take refuge, which is at a right we had not had before, unquote. Ultimately, the issue of slavery's constitutional status was far from settled. At the heart of these antebellum controversies was a more fundamental disagreement. What is the relationship between slavery and the Constitution? Did the Constitution condone, support, and protect slavery, or was it silent on slavery's legality, allowing for the institution to just wither away in the future? Abolitionist Frederick Douglass held a minority viewpoint within anti-slavery politics based on a textual reading of the Constitution. Douglass argued that the Constitution made slavery illegitimate everywhere in the South as well as in the territories. He argued that the Constitution does not explicitly condone slavery, and the written Constitution should not be interpreted in light of a secret and unwritten understanding of its framers. Douglass believed that the federal government could abolish slavery because it violated the Fifth Amendment due process guarantee, the Article 4 guarantee of public republic government, and other clauses of the Constitution. He also made originalist arguments about the founders' intentions to have slavery gradually wither away. By this understanding, the Constitution had become corrupted by acquiescence and pro-slavery custom, but the Constitution's anti-slavery character could be redeemed by federal action. He also relied on a natural law interpretation of the Constitution, arguing that it should be read in conjunction with the Declaration of Independence and given the meaning that best expressed the ideals of the Declaration. Also, from the Black perspectives, we're learning a lot these days about the historical roots of mass incarceration. Think about mass incarceration, where this amendment said that only in a certain context could someone actually be in some force of labor, that if they were duly convicted, that would be the loophole exception. Michelle Alexander's widely successful book, The New Jim Crow: Mass Incarceration in the Age of Color Blindness, now has a cinematic companion, Ava DuVernay's documentary, The 13th. That film's powerful overview of the crisis of mass incarceration from the Civil War to the present has earned its plaudits from critics, activists, and scholars. She refers, of course, to the 13th Amendment language in the documentary, argues that created this loophole that permitted the mass criminalization of Blackness that has defined the post-emancipation experience from Jim Crow to the prison industrial complex. And Senator Cory Booker says that there are more African Americans in prison than there were ever slaves. Is it a new slavery? The film argues that the central dependent clause of this article is the problem, that the country prohibited people from being deprived of their liberty, but with a critical exception. They could now be imprisoned, whether on chain gangs or in modern penitentiaries. The African American went, as the film states, from slave to criminal with one amendment. Many have adopted and extended this argument. One author commenting on the documentary calls the exception clause a poison pill, a trapdoor, an escape clause that permitted the persistence of slavery. That the 13th Amendment says slavery is still legal. Slavery is legal in prisons. The author says, you better wake up and see this conspiracy for what it is. The 2 million people incarcerated in America in 2015 are legally considered slaves under the Constitution, unquote. First, this loophole argument imputes to its framers and judicial interpreters a conspiracy against intentions of full equality that the amendment never included in the first place. All the 13th Amendment did was abolish slavery. It stood virtually moot on the meaning of freedom. Some say and argue this was by design. Anti-slavery legislators wanted a more comprehensive measure, but only by compromising on its vision would more conservative legislators let it pass. It took later amendments and laws to define freedom, right? The Civil Rights Act of 1866, the 14th Amendment of 1868, the 15th Amendment of 1870, and of course, many others. Second, on its face, the language of the 13th Amendment exceptions clause does not offer a mechanism to actively promote incarceration. Instead, its obvious purpose is to ensure that none mistake the prohibition on racial slavery for a prohibition on criminal incarceration. Given the novelty of emancipation at the origin of that phrase, that was not pointless. Surely the abolition of slavery would not mean that no one, black or white, could ever be incarcerated for crimes they committed, right? The exception clause alone did nothing to promote racial oppression. Search in vain for legal cases in which the clause was used to argue for the legality of any form of punishment. Instead, we see the opposite, where the court used the clause to argue against deporting a Chinese woman because it would have returned her to a state slavery in China. Slavery and mass incarceration are not the same. All forms of racial oppression are not forms of slavery. Rather, slavery is one form of racial oppression. Mass incarceration is another. While it may help to end it by associating it with an institution we abolished, it's not the remnant of a barbaric and outmoded system, but the product of a modern society. The problem isn't the persistence of slavery. The problem is how a system that has always promised justice for all always seems to find ways to deny it for some. After the Civil War, new offenses like malicious mischief were vague and could be a felony or misdemeanor, depending on the supposed severity of the behavior. These laws sent more Black people to prison than ever before. And by the late 19th century, the country experienced its first prison boom. Legal scholar Michelle Alexander writes in her book, The New Jim Crow. After a brief period of progress during Reconstruction, she writes, African Americans found themselves once again virtually defensive. The criminal justice system was strategically employed to force African Americans back into a system of extreme repression and control, a tactic that will continue to prove successful for generations to come. States put prisoners to work through a practice called convict leasing, whereby white planters and industrialists leased prisoners to work for them. States and private businesses made money doing this, but prisoners didn't. This meant many Black prisoners found themselves living and working on plantations against their will and for no pay for decades after the Civil War. Like chattel slavery before it, convict leasing was brutal and inhumane. Across the country, tens of thousands of people, overwhelmingly Black, were leased by the state to plantation owners, privately owned railroad yards, coal mines, and road building chain gangs, and made to work under the whip from dusk till dawn, often as punishment for petty crimes such as vagrancy or theft, reports the Washington Post. Many prisoners died in these conditions. In July 2018, researcher Reginald Moore announced he'd found the remains of 95 Black prisoners who died working in Sugar Land, Texas in the early 20th century. Experts estimate their ages range from 14 to 70, meaning some of them would have been born in pre-Civil War slavery, freed, incarcerated, and then forced into unpaid labor again. More than 3,500 prisoners died in Texas between 1866 and 1912, the year Texas outlawed convict leasing because the death toll was too high. States also benefited and profited off of prison labor by forcing chain gangs to build roads and creating prison farms to grow crops like sugar and snap peas. Today, states and private companies still rely on prisoners performing free or extremely low-paid labor for them. For example, California saves up to $100 million a year, according to state corrections spokesperson Bill Sessa at the time, by recruiting incarcerated people as volunteers. I share with you another clip that reinforces this point, and I want you to give thought to it as we move into an era where we are holding a new president and vice president accountable regarding prison reform and regarding this loophole in the Constitution, which really does create the opportunity for mass incarceration, as has been said in many documentaries and many times before, as a form of racial oppression.
All right, later this month, Detroit Public Television will rebroadcast a One Detroit special that looks at the pathways that lead to prison. Here's a look at a segment of the program that focuses on the large prison population in this country.
Look how much African American communities have suffered. You're living in poverty. Your schools are no good. You have no jobs.
You got a new prison industrial complex. Poor folk get caught. Drugs on the corner. But not one executive of a Wall Street bank goes to jail.
We know about the pipeline to prison. How do we stop this thing and turn it around?
You need more police. We need law and order.
The people in our prisons have made some mistakes, and sometimes big mistakes. They are also Americans.
I'm a Detroiter from the East Side, Castech, class of 95. I like the line, you can't move forward unless you know where we've been. Another native Detroiter and Castech graduate, Heather Ann Thompson, knows where we've been too. She's a historian and can tell us how this pathway to prison got started. Mass incarceration. You hear a lot about it. Can you give us some perspective on what mass incarceration really is and why it should matter?
Well, at bottom, mass incarceration was a policy choice. It is something that this country embarked upon in 1965, deciding to handle all social ills, poverty, addiction, mental illness, and really low-level crimes, rather than through the social welfare system, through the criminal justice system. And what this meant was beginning a war on crime that was historically unprecedented. We'd never put those kinds of resources to this before. This is under the presidency of Lyndon Johnson. Johnson is responding to urban protests in cities like Philadelphia and communities like Harlem, by the way, all of which were rebelling against police brutality.
The policies provided more funding for police, ultimately putting more people behind bars. Mark Fancher of the ACLU's Racial Justice Project says, by the late 1960s, those policies and politics went hand in hand.
You also had something else going on, and that was the use of coded language by politicians. Richard Nixon campaigned on a slogan of law and order.
It's time for some honest talk about the problem of order in the United States. Let us always respect, as I do, our courts and those who serve on them, but let us also recognize that some of our courts, in their decisions, have gone too far in weakening the peace forces as against the criminal forces in this country.
And he exploited the reactions of the black community to oppression and to police violence to speak to largely white voters and to say that he was the candidate who was going to bring people back into line. He was going to calm down these insurrections. He never said that explicitly, but everybody knew what that meant when he talked about law and order.
And this is the house I grew up in. Look at it. It's destroyed. I actually grew up during the war on drugs at 6 Mile and Gratiot. My neighborhood literally changed overnight. Crack cocaine caught us off guard. It brought immediate violence, addiction, and misery.
The undeniable fact is that those who became addicted to crack were sick people. They were people who were in need of treatment and rehabilitation. This country chose to treat them as criminals.
So one of the greatest ironies about the drug war, just like with Prohibition in the 20s, when you make something illegal and people have no other resources to lean upon to feed their families, you have created a very, very dangerous economy.
Studies have demonstrated consistently that the rate of drug use among whites and people of color is essentially the same. But if you look, you see a huge disproportion with respect to people of color. And so it has been a very racially targeted campaign. The worst instances of it was the 100-to-1 disparity in sentencing for crack cocaine versus powder cocaine.
And Detroit was really ground zero, both for the drug war first and then the fallout from the drug war afterwards.
Ground zero. Prohibition lasted only 16 years. The war on drugs doesn't seem like it'll ever stop. As a result of running away from a broken home, Detroiter Shaka Senghor saw it firsthand.
I began to hang out with other broken boys that grew up in the neighborhood, and we kind of bonded around our brokenness.
Like many others, at the age of 15, Shaka took the only opportunity that he could see at the time, selling drugs. At 19, he killed a man.
In July 1991, on the night that I fired those fatal shots, what was going through my head in that moment was fear and survival. And when I went into prison, I walked in with all of the anger, the fears, the anxieties that I had accumulated while living my life on the streets. I blamed everybody except for myself, and ultimately I found myself getting in a lot of trouble my first 5 years. I was one of the youngest persons sent to maximum security. At the age of 19, I turned 20 in maximum security prison.
Shaka went to prison during the mass incarceration boom. After that, President Bill Clinton's crime bill ushered in a new era of mandatory minimums, ultimately hurting more African American families while helping fill penitentiaries.
It wasn't really about the fact that laws were being broken. It was about where the policing was where laws were being broken. So, for example, you had more white folks selling drugs and using drugs than black folks, but all the police were dispersed into mostly black and brown neighborhoods.
In the suburbs, you may have a group of affluent white youth who are relaxing in the large home, using some of the most exotic drugs imaginable. But you're not going to find police crashing down doors to try and get to these kids. You're not going to find police in suburban shopping malls stopping and frisking and patting down affluent white youth, even though they may be doing the exact same thing or worse than their counterparts in low-income communities of color.
So ultimately what this means is that the criminal justice system is way disproportionately filled with black and brown youth and eventually older people as they age through the system. And that sends a message to America, right? It just underscores this myth that somehow there's a connection between criminality and blackness.
I don't know that from day to day, prosecutors or even police or judges wake up with the idea that we're going to, lock up a lot of black people. I don't think that happens, but I do think that it has been so much a part of the country's historical agenda that now it has become essentially institutionalized.
There were people I knew who weren't bound to be criminals. They weren't violent offenders at all. But after serving time with the Department of Corrections, they emerged more hardened and more likely to fit the stereotypes some might feel unsafe being around. Shaka Senghor addresses that same mindset in his best-selling book, Righting My Wrongs, where the term corrections is a misnomer.
I was in solitary confinement a total of 7 years out of the 19 years that I served in prison. At one point, I was in solitary confinement for 4.5 years straight. And it is the most horrific and barbaric environment that I believe exists in American society. It's a secret society, clandestine if you will, and it's one of the greatest tragedies because the level of mental illness inside solitary confinement is astronomical.
Somehow Shaka came out with his mind intact, as well as the mission to tell his story as part of the movement for prison reform. While all this gives Heather Ann Thompson hope, she can't help but wonder if we might soon be heading in the wrong direction.
Now, I think it's really unclear where we're going to go. We have a new president who has routinely said that what we need is, to use his words, law and order. And it is deeply distressing to hear that. As a historian and as a Detroiter, those words were the words that touched off 40 years of devastating policies. We do not have a crime crisis right now. We have a crisis of poverty, we have a crisis of incarceration, and we have a crisis of violence in the most heavily incarcerated communities. The idea that we would need more of that we need more policing, that we need more prisons, just flies in the face of what every expert knows, what every mother with children in prison knows, what every child with a parent in prison knows. And so I worry for our next decade.
You can watch the entire Pathways to Prison special on April 13th at 9:30 p.m. That's our program for today. Thanks for watching. You can get more information about our guests at American Black Journal.
I wanted to play the entire resource so that you would know this are resources that we're using that are part of public domain, and we do not own the right to these resources. But I want you to consider in this moment of reflection whether or not the abolishment of slavery, the abolition of slavery, if you will, in the 13th Amendment really didn't speak to the unwritten part of the Constitution, the loophole that really many have gained and profited from the service of labor, the restricting and oppression of people within prison. If you believe that if we don't learn from our history, we're doomed to repeat it, then you will, as a registered voter and an engaged person in our political system, demand for prison reform and demand for legislation that improves the rights of those that are impacted and experience the penal system, and that there is parity where we see such disparate treatment and disparate remedies. I'm Marcus Holmes. I am bringing you another Black History Moment. We are 365 Black, and we are grateful for a global world in which we live. But we wanted to highlight, as everyone just about is in this month of February, the history, the reflections, the excellence, and the sacrifices of African Americans and people of African descent. You know, I'm an HR professional, and you hear a lot, especially during these times, about what's called DEIB. I call it DEAIB. It's diversity, equity, inclusion, and belonging. But I say diversity, equity, access, inclusion, and belonging. I think people impute access or say that access is automatically a derivative of equity. And equity means that you put people on level playing field with all of the tools. But the reality is that if there is a room, an old boys room, an old boys network, whether or not you've been given level ground, the mindset of the room has not changed. You need access to that room to be able to bring your brilliance as an individual. And while it's true that many segments of our society, many demographics have been impacted, that the LGBTQIA has been impacted, that women have been impacted, that indigenous people have been impacted, African Americans by far have been impacted by a constitution whose framers did not intend to give them full citizenry, but hoped that slavery and its ills would wither away. And I ask you this question: has it withered